So a case challenging New Jersey's red flag law and the use of that law to seize an individual's weapons has now made its way up to the Supreme Court. So let's talk about this. But real quick, before we jump into this video, if you think it's time for the Supreme Court to finally uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to let you know that this content is powered by the Firearms Policy Coalition, so head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. Also want to mention real quick that the first episode of the Armed Scholar podcast is now out. You can find it over on the second YouTube channel, as well as you can find it on Spotify, Google Podcasts, and Apple Podcasts. And I will leave links to everywhere you can find the podcast down in the detail section. So the case we're going to be talking about in this video is Pzv New Jersey. And this is a case that has made its way up to the Supreme Court now, and it is a challenge to New Jersey's red flag laws and the use of that red flag law to seize an individual's weapons. So here's some quick background on this case and what it involves. So as a result of a warrant that was issued for so-called safekeeping in conjunction with a temporary restraining order, the individual here, his firearms were seized by New Jersey, and also he had his firearms purchaser identification card also seized. Now, when a superior court in New Jersey reviewed his case, reviewed the final restraining order, they actually found that the individual there did not deserve to have that final restraining order issued against him and did not grant that restraining order. Now, after the New Jersey Superior Court denied that restraining order, the state of New Jersey didn't like that. So they decided to file a motion, and that motion sought the forfeiture of that individual's weapons and of his identification card and that purchase permit. Now, the government did this, and their argument was that under a section of the law, a purchase permit shall not be issued to any person where the issuance would not be in the interest of public health, safety, and welfare. Now, conveniently for the government here, this whole issue of public health, safety, and welfare is not defined. It is not clearly defined anywhere, and therefore courts are free to interpret it however they want. Now, reviewing the state's motion to forfeit this individual's weapons and purchase permit, the court did find that it would be in the interest of public health, safety, and welfare for him to no longer possess firearms. And they came to this conclusion because one of the weapons that was seized, a Century Arms AK, in their eyes was a prohibited rifle. About 25 firearms were seized from this individual for so-called safekeeping, and one of them was found to be a so-called assault weapon, since the court found that it was, and this is kind of one of those vague things again, substantially identical to a listed prohibited firearm. Now, some clarity on the whole banned firearm issue. Like the California Roberti Roos list, it appears that New Jersey also has the same banned item list that specifically names makes and models of firearms that the state considers to be prohibited and therefore bans the possession of them. This Century Arms AK, however, is not specifically named on the list, but the list in New Jersey also has a subdivision that kind of has a catch-all phrase, and that catch-all phrase is what the court used, which is substantially identical. So in their eyes, they believed that this Century Arms AK was substantially identical to another item that was named on that prohibited item list. And using that interpretation, they found that this item was prohibited, and therefore he should not have that item returned to him, as well as none of his firearms should be returned to him, and also that he should have his rights to possess firearms completely removed in the future. So this case made its way through the lower court and has now found its way up to the Supreme Court, and he has filed a writ of certiorari, essentially seeking review from the Supreme Court on this issue. Now, the questions presented to the Supreme Court and why they should review this case are quite a few, so let's go through the question presented. The first question presented to the Supreme Court is, what is the scrutiny level afforded to the Second Amendment right to possess firearms within the home? So this question really is talking about the type of analysis that should apply when a law is affecting an individual's right to possess firearms within his home, which Heller has alluded to being part of the core right of the Second Amendment. The second question presented is, does a state's denial of a person's Second Amendment rights in the interest of public health, safety, and welfare constitute three things? First, an unconstitutional, overbroad, and vague standard, and or an unlawful balancing test in offense of Heller, and or a wrongful denial of due process notice. And the final question presented is a warrant issued to search and seize firearms from a home for so-called safekeeping valid probable cause under the Fourth Amendment? And what this question presented is alluding to, again, is what I mentioned, the Caniglia v. Strom case that was recently decided by the Supreme Court. And this is a direct attack on red flag laws, and is essentially arguing that red flag laws are a violation of an individual's Fourth Amendment rights. Now, there are three main arguments made in this cert petition that I want to talk to you all about and that I think are really important. The first one is this public health, safety, welfare standard is vague, overbroad, yet it is used to strip people of their Second Amendment rights forever without actual due process. Now, to the vague argument, the cert petition states that interests of the public health, safety, or welfare has no defined limit and openly invites judges to, under the pretense of regulating, destroy a constitutional right by deciding on a case-by-case basis through a single or series of successive findings that various behaviors not previously prescribed present a threat to the public. The argument goes on to state that this court would be hard-pressed to find a better example of a law used to deny a fundamental right that is more unconstitutionally vague than in the interest of public health, safety, and welfare. So the whole argument is that the public health, safety, and welfare language is so vague. It is used in a way that courts just manipulate it whenever they need to strip people of their Second Amendment rights, and therefore it should not be upheld because it is so vague. The second argument is that it is just way too overbroad. They state in this section that in the interest of public health, safety, and welfare is not narrowly tailored at all, nor is it limited in time to which is necessary to serve a particular purpose. People concerned with running afoul of the public health, safety, and welfare language are broadly restrained in fear that any action could be found to constitute a reason to disqualify them. So the argument here is that the language is just way too overbroad, it is not time specific, and people don't really know what's going to offend a court, and therefore that court will use whatever conduct that is to say that they are violating public health, safety, or whatever. Now, the last argument made in this section is in regards to due process. They state that notice and opportunity to be heard are fundamental requisites of due process of law. Under the law, individuals have no opportunity to conform their actions to the law because they never know what a court may deem not in the interest of the public health, safety, and welfare until after it rules. So the argument here is under this red flag law scheme in New Jersey, people really don't have any due process rights. It is not until after the fact when the court looks at various facts and situations do individuals ever get put on notice of what the court finds to be actually offending conduct under this public health and safety language, and is used as a kind of basis to strip them of their rights. Now, the second main argument that is being made, and is important because it's springboarding off of a prior Supreme Court decision, is the whole issue of that review is needed because New Jersey is wrongfully issuing search warrants to seize firearms from individuals' homes merely for the basis and rationale of so-called safekeeping. So in this section, petitioner argues that in May of 2021, Your Honors unanimously held that police officers' community caretaking duties do not justify warrantless searches and seizures of firearms within the home. They go on to state that community caretaking is thus synonymous with safety, welfare, and safekeeping. Petitioner's firearms were seized from his home for so-called safekeeping. They go on to state that he was then denied the return of the property in the interest of public health, safety, or welfare. This 1-2 punch is the means by which New Jersey systematically disarms its citizenry and chills the exercise of Second Amendment rights. They then state, and this is where Caniglia comes in Caniglia's concurring opinion, Justice Alito noted, provisions of red flag laws may be challenged under the Fourth Amendment, and those cases may come before us. In other words, petitioner's case presents a search in a non-criminal law enforcement context, anticipated by Justice Alito, and deserves the court's attention. So here they're saying this New Jersey case is exactly the type of case that Justice Alito was alluding to that may become before the courts in regards to red flag laws, and the type of the case that the Supreme Court should actually address. So this is an interesting challenge to a state's red flag laws and the use of those laws to seize an individual's weapons and then also strip that individual of his rights in perpetuity. Now, the last thing I want to put on your guys' radar is that the ATF's proposed rule on pistol braces is closing tomorrow on September 8th. So if you have not left a comment yet, please go drop a comment on the ATF's proposed rule on pistol braces. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It signals to YouTube that you see value in these videos, in this type of 2A news, and then it pushes it to more people. Thank you so much to everybody who's liked, commented, and subscribed, who's helped to fuel that algorithm and helped expand this channel and these videos to more people. Thank you so much for doing that. And if you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and that really does help. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget that Station was built by armed scholars and Station we maintain by armed scholars.